Thank you, Mr. Chairman. The legislation before this committee would do three things. It would alter where state antitrust actions can be heard. It would bring more scrutiny to mergers involving foreign money, and it would alter filing fees associated with mergers. I'd like to briefly address all 3 points. The first provision I mentioned would change how the multi-district litigation panel handles cases related to antitrust. Right now, the MDL panel can centralize overlapping cases in most appropriate venue when there are multiple lawsuits with shared questions of law or fact filed in different jurisdictions. This legislation would dictate that for antitrust actions brought by State Attorney General, the MDL panel could not remove those cases, which can accordingly stay in the chosen venue of the state, the Attorney General of the state of the Attorney General that brings them. Many Republicans support this legislation because, in theory, it would make it harder for a case against a Silicon Valley company to be transferred to a friendly jurisdiction like the Ninth Circuit rather than staying elsewhere in the country. I will note that the Administrative Office of the Courts has sent us a letter expressing a number of concerns and noting the potential for significant negative effects from this bill. In the opinion of the AOC, this change could be harmful to the judicial economy and put further strain on our federal court system. The second provision I mentioned would simply update the relevant statutes to help antitrust enforcers take a harder look at mergers when foreign funds are involved. This is a largely non-controversial idea. Finally, the bill would change the amounts paid by companies to federal agencies to have their mergers reviewed. In a vacuum, the idea of updating the structure of filing fees is a good one. Most people agree that those seeking approval for larger mergers should pay more, and those seeking approval for smaller mergers should pay less. The problem is that the money generated by this change in merger filing fees amounts to hundreds of millions of dollars that would, in effect, be set aside for the Department of Justice and the FTC. Proponents of this bill might note that language appropriating the funds is not included here, and they may insinuate that this money will not necessarily fund the Biden administration, FTC, or the DOJ, but that is highly misleading, and there's more here than meets the eye. Everyone acknowledges this bill is designed to increase revenues that are intended for use by the FTC and the Department of Justice. That's why I'm urging opposition to this bill. When we marked up the legislation, Democrats rejected several Republican amendments that focused use of the funds on enforcement rather than empowering woke progressive policies. Republicans offered these amendments to limit misuse of agency resources and restrain funding from being used for unlawful ends. Democrats rejected each amendment, and they have cut from the bill before us adopted language that addressed the use of funds beyond amounts appropriated. This is deeply concerning. If you believe, as I do, that these funds will ultimately end up in the hands of activist bureaucrats at the DOJ and the FTC, this legislation should be rejected. President Biden's FTC bureaucrats are using their power for radical purposes beyond their statutory authority to seek control of the economy. For example, FTC Commissioner Rebecca Slaughter tweeted the following: "It is perfectly appropriate for us to use our existing antitrust enforcement tools wherever possible to right the wrongs of systemic racism. Indeed, I believe it's our responsibility to do so." She continues, "Antitrust can and should be anti-racist. Antitrust is about ensuring fair opportunity for all competitors to the benefit of consumers. As long as black-owned businesses and black consumers are systemically underrepresented at disadvantage, we know our markets are not fair. We need to fix these inequities," end quote. Ms. Slaughter also has said, "I'm simply suggesting that we begin to think strategically about using antitrust as a tool for combating structural racism." FTC Chair Lina Khan has argued that a new conception of antitrust will address inequality. She said, "A revised antitrust movement could play an important role in reversing the dramatic rise in economic inequality." These goals are simply and completely beyond the province of antitrust, and we should not entrust unelected folks with more money. This is especially true because the Judiciary Committee has yet to hold a hearing with Chair Khan to understand how she would use new millions upon millions of dollars in antitrust resources. Thank you. I urge opposition. I yield back.